Next case is LINDON versus Dalton Hotel Corporation.
Good morning. May it please the Court. My name is Tom Young, and I'm here this morning on behalf of Appellant Harold Dale Lindon. I would like to reserve 4 minutes for rebuttal. We're here today because Mr. Lindon is asking this Court to reverse the trial court's judgments, reinstate the jury's finding in his favor, and remand this case for discovery and new trial on damages and for an award of attorney's fees and costs.
Mr. Young, would we be having this same discussion if the trial court had ordered a new trial finding that the verdict was against the manifest weight of the evidence as opposed to the J&OB or the directed verdict? I mean, essentially, well, that's my question.
Well, Your Honor, that's a good question. No, I don't think so. I think, well, to tell you the truth, I haven't thought of that question, so I can't answer that question directly. I apologize. There is, however, plenty of evidence to support the jury's verdict. I don't believe that a trial court finding that the case or that the jury's verdict was against the manifest weight of the evidence would be an appropriate finding because, as I've pointed out in both the initial brief and in the reply brief, there were no less than 10 or 11 areas of evidence that the evidence was in conflict. Everything from working without remuneration to the absence of employment documents to sworn employment documents that Mr. Lindon's employment started 7 months after this stockholders agreement was signed, to contradiction between Mr. Dalton's testimony and the testimony of his attorney, the absence of corporate documents concerning what Mr. Lindon's position might have been. There were all sorts of evidence that permitted the jury to reach the determination that it reached on the verdict form, which was that Mr. Lindon was not an employee of Dalton Hotel Corporation when he signed the stockholders agreement in February of 1999. And of course that was the pivotal fact finding because Article 2 of the stockholders agreement had no application unless Mr. Lindon was an employee when he signed it.
Question?
Yes.
If he signed this in roughly February, March of 1999, but he was performing services for the corporation as early as 1998, from the period he started doing that until February, March of 1999 when he signed the shareholders agreement, if he was an employee, what was he then?
Your Honor, that's the same question the trial court posed, and my first response to that is it doesn't matter what he was. If he's not an employee, then the stockholders agreement is not applicable to him. The evidence demonstrates that Mr. Lindon was simply a man pursuing an investment opportunity. He is an experienced hotelier. Mr. Dalton had an idea. he needed an experienced person. The loan documents from Wachovia Bank demonstrate that this could not come to fruition without Mr. Linden. He asked for Mr. Linden's help. Mr. Linden was an independently employed consultant in the hotel business, I think the record shows, was working with CFI Investments at the time Mr. Dalton, or was consulting with CFI Investments at the time Mr. Dalton approached him. So, according to the record, you can consider Mr. Linden an investor. Here is an opportunity to make this dream come true, and as a result, you're going to have a vested ownership interest, 8.75%, in fact, ownership interest in a major hotel in downtown Orlando.
Well, it seems like, I mean, there's no question that, part of the deal here was that Mr. Dalton was providing the financial wherewithal and your client was providing the hotel experience. But your client, prior to the time they executed the shareholders agreement, your client was signing documents on behalf of the corporation, was binding the corporation to a number of things. And that's not something, and when your client was asked, well, what were you? If you weren't an employee, what were you? And there were a number of different answers, but he seemed to settle on, well, I was a shareholder. And as I think you concede in your brief, or I think you would concede, shareholders can't typically bind a corporation.
Your Honor, there are a couple of things that you've just said that aren't supported by the record, in fact. There is no evidence in the record that Mr. Linden signed with this honorary title of Vice President of Operations before he signed his name on the stockholders agreement. There is documented evidence in the record that Mr. Linden was representing himself to people as a partner. And in fact, in January of 1999, he received mail at his home, and again, it's in evidence that confirms, you and your partner are doing, or you and your partners are doing great work, or something to that effect. So there is, yes, Mr. Linden was working to make this hotel a reality, but there is no evidence in the record that he was doing it as an officer of the corporation. And beyond that, Your Honor, I would point out that there is no evidence that Mr. Linden was, in fact, an officer of the corporation. Under Florida law, an officer is someone who is named in the bylaws or who is appointed by or elected by the directors.
Didn't he have cards printed up that said Vice President of Operations?
The record demonstrates that there were business cards that showed Mr. Linden to be the Vice President of Operations. The testimony was that those cards were printed sometime in the first quarter. There was nothing more definitive than the first quarter of 1999. And what I would point out is that the stockholders agreement was signed, well, there were conflicting dates on two stockholders agreements, but one is dated February 2nd, 1999. Well, the first quarter ended March 31st, 1999. So essentially we have 2 full months where these cards could have been printed and used after the stockholders agreement was signed. So the business card is a piece of evidence that, again, is conflicting, but the conflicting evidence is precisely the point. It's precisely what made this a jury question. And the judge overstepped her bounds when she set aside the jury verdict, finding that Mr. Linden was not an employee when he signed that stockholders agreement. And again, under the language of the stockholders agreement, the shareholders could cause the corporation to redeem Mr. Linden's stock only if he was employed at the time he signed that agreement. And because there was conflicting evidence and because the jury resolved that conflict in Mr. Linden's favor, the trial court's judgment of JNOV for the corporation needs to be reversed. And for the same reason, the trial court's directed verdict in favor of Mr. Dalton personally should be reversed. It's clear that Mr. Dalton is an employee, is a party to the shareholder agreement. I mean, that's what a shareholder agreement is, an agreement between the shareholders. And that document defines the relationship between the shareholders. And that document says that the majority shareholder can only vote to cause the corporation to redeem an employee's stock if that other shareholder was employed at the time he signed the agreement. So we cited you a case from Georgia. I didn't find any cases in Florida on point, but it seems axiomatic that a shareholder is bound by a shareholder agreement and is personally responsible for personal action, i.e. voting personal shares in a manner that is not authorized by the shareholder agreement. And the trial court's reliance on Section 607.0732 is simply not, it's a misapplication of that statute. That statute certainly says a shareholder has no personal liability for actions of the corporation that are authorized by the agreement, but that's the whole point. It was not authorized because the jury found for Mr. Linden that he was not an employee at the time the agreement was signed.
If we were to agree with you on the points that you've raised so far, where does that leave you, though, with your damage award?
Well, that's why we need to go back for discovery, Your Honor. I like to say change one thing, change everything. And the case, from a damages standpoint, became problematic when the first judge limited discovery. Mr. Linden sought certiorari review in this court, and that petition was dismissed. So the issue is ripe for review now. Your Honor and Judge Griffin were both involved in the mnemonics case, and I believe that case tells us what the measure of damages is when you have a breach of contract, and we also have the tort claims that we've raised on appeal. But when you have a claim and there is no contractual provision for damages, and because Article 2 doesn't apply, Article 4 does not apply. Article 4 was the provision that established the adjusted book value. Absent a contractual provision, the damages are those damages that flow naturally from the breach and that could have been reasonably anticipated by the breaching party when the contract was signed. Clearly, it was foreseeable that if a person, a minority shareholder, was involuntarily divested of his stock, that the breaching party would, at a minimum, be responsible for the value of that stock and possibly for the profits that breaching party realized from the stock that they plundered. So we submit that pursuant to the mnemonics decision, Mr. Linden is entitled to the greater of the fair value of the stock at the time it was taken, or the amount of the profits that Mr. Dalton subsequently realized upon selling the stock that he took via the corporation from Mr. Linden. And I would submit to the court that the damages analysis is as simple as that. There's plenty of case law that supports the disgorgement theory, and the Second District in its Athletech decision from 2004 quotes the 1937 restatement on restitution, which talks about either giving back what was taken or dislodging the profits that the wrongdoer has realized. So the law generally and the law of this district in particular is well settled on what the remedy would be. With regard to the tort claims, again, I would submit that the case law of this district resolves the issue. Both the Duncan case that you, Judge Orfinger, are on, or the I think Nirvon case, Judge Griffin, that you were on. Both of those cases talked about the economic loss rule not barring tort claims where there is an extra contractual duty and where the conduct is not just non-performance but actually affirmative intentional conduct. And that's what we have here. We have a fiduciary duty that is not dependent on this contract. And of course, even if it were, there is authority in this state that does not bar the fiduciary duty claim under the economic loss rule. But under this district's case law, the fiduciary duty came into existence separate and distinct from this contract. It came into existence when Mr. Linden became a minority stockholder. So under the Nirvon case, or Nirvon, I apologize, I'm forgetting the name, but the extra contractual nature of that takes this case outside the economic loss rule. And under the Duncan case, the affirmative nature of this action takes this outside the economic loss rule. In a final note, I would point that the Ohio Supreme Court adopted this court's decision, 1981 decision in Tillis, talking about the equal opportunity doctrine and that majority shareholders owe minority shareholders equal opportunity. And Mr. Linden's equal opportunity claim is not dependent on whether or not he was employed when he signed the stockholders agreement. And I want to emphasize that to you because the Ohio case that we cite in turn cites a Massachusetts case, and of course Tillis was grounded on a Massachusetts decision, so it all comes full circle. But the Massachusetts Supreme Court has also said that a majority shareholder's removal of a minority shareholder from the payroll constitutes a breach of the equal opportunity doctrine. And here, rather than terminating his employment, Mr. Dalton simply stopped drawing a salary. And so Mr. Linden's alternative breach of fiduciary duty claim is that Mr. Dalton had an obligation to permit, rather than terminate Mr. Linden's employment, had an obligation to also allow him to continue working without remuneration. I will reserve the rest of my 2 minutes and 40 seconds for rebuttal. Thank you.
Thank you, Counsel.
Good morning. May it please the Court, my name is Chris Carlisle. I'm here this morning on behalf of Dalton Hotel Corporation and Roy B. Dalton, Jr. Your Honors, this case represents or brings to this Court a situation where a party, Lindon, a sophisticated businessman, entered into an arm's-length transaction that ultimately he was dissatisfied with. And he spent years having this case wind its way through the court system, attaching his entire hope to a loophole in the contract where he claims that I was not an employee and therefore this contract that I entered into, which he freely admits every other provision applies to him, but this one doesn't, a position he never took until Dalton Hotel Corporation lawfully redeemed the shares that they had a contractual right to do. This loophole has caused years of litigation. It was ultimately resolved by the trial court post-trial, and it was done so appropriately. Judge Orfinger, and I believe it was you who raised the question about, and it is the key question that the trial court struggled with post-trial, and that is, if he was not an employee, what was he? The strategy has been, and we see it continuing today, to never take a position on that. We were something else. We were some amorphous concept not recognized in the law. It's contrary to what he actually testified to. The testimony below, and we go through it in the brief, was that his obligations, his duties, his full-time work on behalf of the hotel corporation, negotiating contracts, talking to Embassy Suites, dealing with a variety of things, did not change from October 1998 through February 1999 through August 1999. He's doing the same things. During this period, he's holding himself out as Vice President of Operations. At trial, he was asked, what were you? What was your role? At first, he said partner. Then he says, well, that's actually not true. I wasn't a partner. I was a shareholder, which again begs the question, what was he doing between October 1998 and February 1999 when he signed the shareholder agreement? What was he doing then? There is no explanation for this.
Well, do you agree that if he was not an employee of the corporation at the time he signed the shareholders agreement, that the provision that we focused on in this case doesn't apply?
That's been the contention and the factual issue in this case.
So we're probably all at least in agreement that the key question of his status as an employee is relevant. And if we look at, among other things, it seems to me that we've got two things in the record, at least two things. We've got his testimony, which the jury certainly was free to accept or reject. We got his testimony that I'm not sure exactly what I was, but I wasn't an employee. I mean, I agree it's a moving target as to what he was, but he was clear he wasn't an employee. And we have the I-9 form, which says that his first date he was first employed by some date post agreement, I forget, several months later.
August 1999.
And I certainly agree with you that there was a reasonable explanation from Miss Hurd, I believe her name was, as to how that date came about, that it very well may have been just a clerical error. But nonetheless, we've got this form that says he was first an employee on some date other than the relevant date, and his testimony. Was the jury free to accept that testimony? For example, well, let's put it this way. Was the jury free to accept Mr. Lindon's testimony that I wasn't an employee? I may have been something else, but not an employee.
Your Honor, you raise really obviously the key question in the post-trial period we're talking about here. And I think it's important for the court to look at the trial court's analysis of this. Two post-trial hearings where it dealt with and wrestled with just that question. And I think the trial court rendered its decision based on two individual bases, which I think is important for this court to recognize. The first being, again, purely under the standard that no reasonable juror could have come to this conclusion in light of the facts and circumstances of this case.
Is that more of a manifest weight of the evidence?
Well,
and if so, wouldn't the remedy be new trial, not directed verdict?
Your Honor, again, respectfully, I don't think it's a manifest weight of the evidence. I think that she clearly found that no reasonable juror applying the appropriate standards could have found in this case. The reasons being...
Well, how does that differ from verdict as against the manifest weight of the evidence?
Well, Your Honor, I'm sorry. You're asking in the context of a new trial in this case?
Well, the remedy for a verdict that's against the manifest weight of the evidence is a new trial, whereas if there is no evidence to support it, then it's a directed verdict.
Right.
And
again...
So I'm trying to understand
sure.
if...
I'm trying to answer your question in two separate ways that the trial court did. And the first being, again, looking at it purely in the situation of the reasonable juror, which the court did. You point to two issues that the trial court, again, dealt with. The first being Mr. Lindon's testimony. And based on Judge Torpey's concurring opinion in the Bassett, I believe, case, Bassiano case, I'm sorry, from this court, found that, if that was the case, if a party was allowed to give self-serving testimony in the face of all other evidence, then we'd never have a directed verdict. If we're allowed to...
Let's talk about all the other evidence then. What is all the other evidence?
Well, again, all the other evidence, Your Honor, was that, again, that he worked from that time all the way through, never changing his duties, always doing the same thing, and leaving unexplained his status during the 4 months prior to the entry of the shareholders' agreement. The court found that based on...
What is the evidence that he was an employee?
Your Honor, I think that, again, the court identified three bases. Number one, he didn't draw a paycheck until August 1999, which no one did, and there was obvious explanation for that.
That suggests he was not an employee.
Well, I'm saying this is what they relied on or what they raised before or at trial. They said, well, we didn't get a paycheck. However, no one did, and he acknowledged that
The
until...
trial court was very careful in refuting reasons why he may not have been an employee, but I didn't see anything that constituted evidence that he was an employee. What is the basis for refuting the notion that he was?
Well, Your Honor, again, he held himself out as Vice President of Operations. The trial court focused on a Florida statute that said officers of corporations are, in fact, employees.
Was he an officer of the corporation?
Yes. He was Vice President of Operations. That was the role he fulfilled from day one. That was what his duties never changed. The court focused on that. And I think, again, we need to...
How did he become Vice President of Operations?
That was, again, there was not, again, a specific resolution to that effect. That was, again, the role that he assumed. I think that was the understanding that he was going to be an officer, that he was going to work for the company.
If I go around representing to myself that I am the Vice President of Operations for your law firm, then that makes me an employee of your firm.
No, Your Honor. But I think that, again, in this case, he was doing it with full knowledge of the other folks that were involved in this. There was no suggestion that he was doing it inappropriately. I think, again, if I can back up just a little bit on this issue, whether or not we're weighing the evidence or looking at the evidence that was presented and the reasonable juror standard, I think it's important to recognize the trial court also found, and again struggled with this, that he did not present any cognizable legal theory as to what he was.
Let me ask you a question about what he was. He was issued 25 shares of stock, right?
25%, yeah.
Ms. Hurt, I thought it was 25 shares. Well, there were 100 shares, so it was 25%.
25%, 25 shares.
Ms. Hurt was issued 5.
Correct.
And Mr. Dalton received the remaining 70, right?
Yes.
And they all started working together in 1998, and then without a paycheck, and then in, depending on who you believe, February, March of 1999, they all signed a shareholders agreement. They all did the same thing, right?
Correct.
So let me ask you. Prior to signing the shareholders agreement in February, March of 1999, what was Mr. Dalton and what was Ms. Hurt?
They were employees of the corporation. They were working for the corporation to bring this project forward.
Right.
The payment of money...
Did there ever come a time where Mr. Dalton ceased his employment with Dalton Hotel Corporation?
I don't believe he ever ceased his employment. He ceased taking a paycheck at some point because the corporation was experiencing financial difficulties. But again, the court...
Was there anything more
I'm
in
sorry.
the record that he, just beyond not receiving a paycheck, did he ever relinquish his shares in any fashion?
Did Mr. Dalton relinquish his shares? I don't believe so, Your Honor. Is there something
anything
that you're...
in the record other than he stopped receiving a paycheck that would indicate that he ceased employment with Dalton Hotel Corporation?
I don't believe so, Your Honor. We're talking about Mr. Dalton here? Not, as opposed to Mr. Linden, Mr. Dalton? I don't believe so. But again, I think if I can just focus on that one point, just finalize it before we move on to a couple other issues. The point being that there are cases where the court has directed a verdict or has reversed, and for lacking of doing that, where someone failed to meet the legal standards of a cause of action, for example. In this case, Linden takes the position that I am a shareholder, which obviously doesn't fit. He then comes back post-trial and says, well, he was an agent. This was never discussed or brought out, and there was no mention of that to the jury in this case. So then the court says, well, isn't it incumbent on you to articulate some theory as to what you actually were? Is it enough to present this moving target and say, well, I was a partner, no, I wasn't, I was a shareholder, but that doesn't count for those 4 months, I was an agent, maybe I wasn't. And the point being, the trial court, beyond just saying no reasonable juror on this evidence could have found that he was an employee, says, I recognize, and questioning of counsel post-trial, that there is not a viable legal theory that he is putting forth before this court to explain what he was doing there. And if there's no viable legal theory, then therefore he was an employee because of all the evidence that he supplied concerning his activities, etc., with the corporation. So I think when you're looking at the trial court's ruling, you have to look at it in essentially two ways. One being the analysis of the reasonable juror based on the evidence, and the one being a pure question of law. Isn't it incumbent on him to go forward and take this case to a jury to have articulated some cognizable legal theory as to what he was, which he failed to do? And the trial court focused on that in rendering its decision. If I can move on.
Let me just ask one last question on that. In the trial court's ruling, she writes that Ms. Hurt adequately and credibly explained the circumstances under which the I-9, which sets the employment date post-agreement,
Yes.
was executed, why that date was picked. But nonetheless, it says what it says. Wasn't the jury free to reject her testimony and accept the date that was written on this form?
Your Honor, I think also if you look at what the trial court said in the post-trial hearings, it did find that the I-9 form was not conclusive because of the explanation that obviously until they started receiving paychecks, there was no need for that form to exist. But she also said, nor does that form supplant the facts surrounding Mr. Lindon's association with DHC. And I would submit that if not for that form, we wouldn't be having this discussion because that is the one thing that is somewhat tangible that can be latched onto here. The trial court concluded that no reasonable juror could have found that that thin thread was enough to supplant his own testimony regarding his activities, etc., and all the things that occurred to that point.
Well, when the trial judge seems to make some hay, she said Mr. Lindon's own testimony that he did not consider himself an employee. This testimony is self-serving, as recognized in Judge Torpy's concurrence in Banker's Trust. Such self-serving testimony doesn't constitute competent substantial evidence.
Correct.
I mean, are you suggesting that self-serving testimony, and that seems to be a pretty doggone broad statement. First of all, I'm not sure what precedential value a concurring opinion has, but are you suggesting that as a rule of law, testimony that's not self-serving is not competent substantial evidence?
I'm suggesting that Judge Torpy's concurrence states that self-serving testimony standing alone is not sufficient to constitute competent substantial evidence. And again,
so if this case had been nothing more, if there were two witnesses, Mr. Lindon comes in and says, I was an employee of the corporation from this date forward, I did X, Y, and Z. And Mr. Dalton or Ms. Hurt came in and said, oh, no, you weren't, and here's why. I mean, if that's all there was, and I mean, the jury couldn't say, well, we believe Lindon, and, you know, yeah, it's self-serving. Everybody's testimony is just about as self-serving.
I understand. But the point I think the trial court was making was that in light of his testimony regarding his activities, regarding his lack of any cognizable status, that wasn't anything a reasonable juror could have latched onto for that proposition. And when you are offering, again, when you're, again, essentially contradicting yourself, you're not relying on any other evidence besides saying it is so, that was the point there. Now, of course, testimony will be self-serving. Parties offer that in support of their position. But I think what she was focusing on here was the lack of other evidence, the lack of anything to corroborate that, and that's why she discounted his testimony.
Why is that necessary? And if she discounts it, isn't that a credibility determination left to the jury?
Your Honor, again, I think that the issue of a reasonable juror was the standard that she applied here. And a reasonable juror hearing that I'm a shareholder, I'm a partner, I'm this, I'm not that, then him saying, by the way, but I wasn't an employee, she came to the conclusion, I think appropriately, that no reasonable juror could have gotten there. But again, I think beyond this analysis of the various pieces of evidence, the question has to be considered, what was he? And if he can't articulate, which he never did, what he was, then I think that was an alternate basis for the court to grant the motion.
If I may, on that,
yes, Your Honor.
I think that you and I are in agreement that whatever Lindon and Hurt were, Dalton was as well, correct?
Yes.
Okay, and you said that Dalton was an employee and they were all employees, correct?
Yes.
Okay. And Dalton himself said that he was an officer, just like Lindon was, and that they, as officers, they were employees of the corporation even prior to signing the shareholders agreement in February, March of 1999. Is that right?
I believe so, yes.
Okay. Well, in terms of conflict of evidence, what effect that, I believe it was Dalton who called his own attorney, his corporate attorney Humphreys, at trial, and Humphreys testifies Dalton was never considered to be an employee of the corporation. Ergo, if Dalton's not an employee of the corporation, then neither is Lyndon.
The attorney clarified that Lyndon, the understanding was that Lyndon was in fact an employee.
But Dalton was not.
There was one line of testimony that regarding Dalton that I think that where he was somewhat ambiguous on that, but he was absolutely clear regarding Lyndon's status at that time.
Going back to credibility then?
Your Honor, I think, again, somewhat the point being that reasonable jurors in the face of all this evidence, but I think, again, secondarily, and I understand that it was a tough call for the trial court to make, and the trial court did make it, and I understand the questions directed to that today. But the legal issue, as his status as a matter of law, I think is the alternate basis the trial court used to find as it did, and I think it's a legitimate point the trial court made. You can't come into court and attempt to prevail on this by saying I was something that the law doesn't recognize. You have to be something. You were doing this work in some fashion. If you're a shareholder, what were you doing for the 4 months before that? Again, that, I think, was what the trial court focused on as much as talking about these various bits of evidence and how a reasonable juror couldn't have come to that conclusion.
On
Yes,
evidence and in terms of value or damages or anything of that
Yes.
nature, remind me, what was the evidence adduced at trial by which Dalton convenes the shareholders a meeting and then, pursuant to the shareholders agreement, deems that Lyndon has tendered the shares back to the corporation because Lyndon is terminated as an employee? What is the evidence that Dalton is entitled to then purchase, Dalton and Hurt are entitled to purchase the 25 shares at zero value?
The evidence, you mean what was the valuation that was going on there? The valuation.
How does the valuation
Yes.
for that period of time from 98 to 99, or actually 2002 when Lyndon's terminated, how did the valuation for those 25 shares come to be zero?
Your Honor, if you look at the contract, I believe it's in Article 4 that goes through the analysis, and there was evidence presented at trial from the CPA that did the analysis at the time that the last month prior to termination, that's the valuation that's used. It was fair market value. September 11th, 2001 happened 6 months before this. The company lost, and there was testimony. It was in the negative $760-some thousand at the end of that year. There was evidence put forth by the accountant that as of March 31st, which was the date that was used pursuant to the terms of the contract, it was still running at a negative, in the negative. The question about what damages were appropriate, the trial court resolved that at trial, saying, look, the contract says the way we measure damages, this is the way we're going to do it.
If the contract isn't applicable, if we were to reinstate the verdict wherein the jury found Lyndon to be an employee, what's the correct measure of damages?
The correct measure of damages was what the jury found. Well, again, the correct measure of damages is the valuation according to fair market value as of the date.
But if the contract doesn't apply, then how does that valuation apply?
Again, the contract has to apply in the sense that he was bound by the contract. He signed the contract.
Well, but his...
And if we're suing for
being
breach of
bound by
contract,
the contract is dependent upon whether he was or was not an employee. I mean, I think we've agreed to that. So if we, just for the sake of my question,
yes,
if we assume he was not an employee, excuse me, if we
assume that he was an
so he
employee.
was not an employee.
Not an employee,
I'm confusing myself.
Yes.
He's not an employee, then how does that contractual provision even come into play?
Because, again, the count that went to the jury that we're talking about here is a breach of contract count. And so... Well,
but the way it was, the jury was instructed, they weren't given an instruction that would address that issue. I mean, the court pretty much directed a verdict and said, you know, we're going to just give it a book value, adjusted book value.
The court recognized the parties stipulated that it would be entitled, as a matter of law, to determine the value. It was a breach of contract action. The right that Lyndon had flowed from that contract. The contract specified the means of determining damages and the date that they were done, and therefore, because, again, it was a contract action that was there, that was the appropriate measure. That was what the trial court found. I see I'm over my time. Are there any further questions?
Well, I have a question following up on that.
Yes, sir.
if he's not deemed to have tendered his shares, then from what date do we calculate the measure of damages?
Well, Your Honor, again, I think the trial court went through an analysis various times, whether it was, again, back when the tort counts were being addressed, and I didn't get a chance to address the economic loss rule implications here, but I will rely on our brief for that. The date of the action of the tort, the date of the wrongful action or the breach of the contract was the date that the shares were, again, improperly redeemed. And so whether or not, the ultimate decision that was made by the jury, the action still flowed from the date that this action occurred. And it was a breach of contract action, and the contract determined and defined the damages as being from that date. And that was what the trial court focused on, what the trial court found.
So if an action is extra contractual, then you're still bound by the damages that are set forth in the contract for an extra contractual act that's not contemplated by the contract?
First of all, there was not an extra contractual act.
I understand. I'm
because
just
Dalton
asking
Hotel
in a hypothetical
Right.
situation.
Well, again, it's a breach of contract action. The whole point being that it was contemplated by the contract, and the contract specified the damages that were set forth there. If the termination occurs, Dalton Hotel Corporation had the right to purchase back those shares. It exercised that right. The valuation was, again, from the time that was defined by the contract. Again, the way this case continued to sort of go off track was by taking it from a fairly straightforward contractual matter and continuing to make it something else. And saying, well, the contract specifies the damages, but we're not going to go with that provision. The contract says if I'm an employee, I wasn't an employee. There's always a means in this case to try to avoid the terms of the contract. And so, again, this is a contract action. It's a breach of contract action. The breach of the contract itself set forth the measure of damages and the way they were calculated. That was what the trial court focused on.
Thank you very much.
Thank you very much.
May it please the court. One thing I want to emphasize right now is that we are not dealing with a, quote, loophole. What we are dealing with is a contingent contract, and the contingency was not satisfied by Mr. Dalton. Therefore, the contract has no application. And so the attempt to portray Mr. LINDON, someone who sacrificed a number of years of his life for this project, as being greedy just needs to fall flat. This was a contingent contract, and the contingency did not exist. Following up on what Judge Roberts was asking with regard to the status of the employees, and it's clear the court has a handle on the conflicting evidence that makes the trial court's judgments reversible. But
I need to ask you a question about that, please.
yes.
I'm not sure I do have a handle on it from your perspective. So the Reader's Digest version, 25 words or less, pick your best three. What are the conflicts in the evidence regarding whether or not LINDON's an employee? Articulate three for me.
The conflicting evidence, whether he is?
Articulate three conflicts in the evidence, if you can, as to whether or not LINDON's an employee.
Mr. LINDON testified he was working for himself. Mr. LINDON paid for his own insurance, his desk, his cell phone. He was receiving mail at his home. He was holding himself out as a partner. He was receiving mail from people he was talking in terms of partnership. The contract itself says employee, comma, if any, which indicates that somebody who was signing that agreement may not have been an employee. There were a number, Your Honor, and I would just direct you back to our reply brief, because I run through a list of 10 factors there. Another thing I would point out is that when you hire an employee, state law, we've been talking about the I-9, but state law also requires that you pay unemployment tax, that you file certain forms. There was no evidence that any of that was done either.
Aren't those all a function of payroll, though? So if you have no payroll, I mean, I'm not an employment law expert, but I thought that all the workers' comp and unemployment comp stuff was a function of payroll.
Your Honor, the record is vague in that regard. That was not articulated in the record as a defense to the evidence that these things weren't done. So I am out of time.
Well, let me just ask you one final question, I think consistent with Judge Roberts' question, which is, I think the problem that the trial judge was having was with the notion that an individual can hold himself out as an officer of the corporation, do the work of an officer of a corporation, and then after the fact come back and the law will allow him to say that he was not indeed an officer of the corporation. What do you say to that?
What I would say to that, Your Honor, number one, is that an officer of the corporation under Florida law is someone who's named in the bylaws or who's elected by the directors. There is absolutely no evidence that the bylaws for Dalton Hotel Corporation name this vice president of operations as an officer. There is no evidence that there is any corporate documentation that Mr. LINDON was ever elected to that position.
But that's true both before and after the agreement, and yet there's no question, but after the agreement, he proudly wore that flag.
Your Honor, after the agreement, it doesn't matter because
but you're saying this is a non-existent position. I mean, you're essentially saying he was an imposter. I mean, I don't think anybody, including Mr. LINDON, contends he was an imposter. He was out there doing things that clearly had benefit to the corporation.
He was trying to bring an idea to fruition for his own and for Mr. Dalton's and for their investors' financial benefit. But the agreement, the only issue is whether Mr. LINDON was currently employed at the time he signed this agreement. The agreement doesn't require that he be anything else or that he prove that he was anything else. The evidence is that he started, using that title at some point after he signed the agreement. There is absolutely no evidence that he was using that title, that he was handing out business cards, that there is no documented evidence admitted in this record that shows he used that title pre-stockholders agreement.
Or that he did any other actions that an officer would do.
Or that he would do any other, absolutely, he wasn't an officer.
All right.
Thank you.
Thank you, counsel. Well argued on both sides, thank you.